each of you. Are we missing somebody?
All right, I'm going to start with the first person seated, so go ahead.
Thank you. Good morning, Madam Chair, members of the committee. My name is Adam Ballout, and I'm an attorney representing parents involved in dependency proceedings. My practice is in Everett, and so in Snohomish County, children over 12 are automatically appointed an attorney. Over the last 9 years, I've been able to see the direct impact of cases in which there is an attorney versus cases in which there isn't. An attorney appointed for a child at that initial 72-hour hearing can help identify potential relatives and friends to act as placement or support, begin the background check process, call those proposed placements as witnesses, and present evidence about their suitability directly to the judge. This cuts through weeks of DSHS turnaround times, DSHS policy, which often ties the hands of social workers. When we miss this opportunity, the next regularly scheduled contested hearing is about 30 days later with a social worker change in between. That misses out on critical bonding time between a child and a parent. Typically, it's 2 hours, 2 times per week of visitation in that time. In my experience, when children know that they should be going home, but they're not due to red tape or delays, they lose faith in the system. They lose faith in the social workers and ultimately the courts. And when they go on the run or enter homelessness, they are caught up in the juvenile justice system. One study found that 2/3 of King County youth in the juvenile justice system also had involvement with children's administration. Legal counsel can act as a safe, confidential, and trusted source to help get kids back into the system after being on the run as well. As a parent's attorney, I've witnessed firsthand the value of children's attorneys in ensuring that children reach a safe and stable home as quickly as possible, and I very strongly urge you to vote in favor of House Bill 1251. Thank you.
Thank you. Go ahead.
Good morning, Madam Chair and members of the committee. My name is Alicia Leviju, and I'm an acting instructor with the University of Washington School of Law in our Children and Youth Advocacy Clinic. I'd like to start today by thanking you for inviting me here to speak. Over the past year and a half, among my other duties, I have worked to collect data on what exactly is happening in these courtrooms across our state. This is the study we've heard referred to a few times by Representative Frame, and which you all should now have copies of. We observed nearly 900 dependency proceedings, myself, law students, and community volunteers in Pierce, King, and Snohomish counties, and what we found was troubling. So first, something that was already mentioned by Representative Frame. In Snohomish County, for example, we saw that 30% of youth had no advocate present for them. No CASA, no GAL, no attorney, 30%. We also found that 22% of children in combining all three counties, 22% of children were never even mentioned in these court hearings that are supposed to, that are controlling every aspect of their lives. We found that when a child has both an attorney and a CASA, that rate drops to 4%. Another thing we found is that there's a great disparities county to county in terms of how children are being represented in court. For example, children in Pierce County are much less likely to have the support of an attorney than children in King and Snohomish counties. There was an earlier question about the availability of resource attorneys. On page 21 of the report, you'll see that the use